thank you for joining us. My name is Katie Perez and I'm a Senior Associate at Scott Legal PC. Today we're going to spend some time talking about the Extraordinary Ability visas and green cards, but just a few things before we get started. Some of you may know that the firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E-2 visa and has been on several different visas, including an F-1, a TN, a B, and an H-1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including the E-2, E-1, TN, L-1, family immigration, national interest waivers, EB-5, extraordinary ability visas, and more. So we will continue this webinar series, doing at least 2 webinars a week on different topics. And at the end of this webinar, we will send you several useful tools. We will send you a copy of the PowerPoint presentation from today. And we'll also send you a link where you can sign up for additional webinars. The webinar will be recorded and it will be available on YouTube. We'll also send you a link for that. And we do encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange for a consultation with one of our experienced attorneys if you would like to discuss your case in more detail. If you do have any questions throughout the presentation, please feel free to put them in the chat box and we will address those at the end of the presentation. So today I will be presenting the first half of the webinar, and we are joined by another senior associate here from Scott Legal, which is Jiyae Hwang. And Jiyae is a graduate of Harvard University, and she earned her law degree from New York University School of Law. She is a very accomplished individual and an amazing resource and has advised many professionals on the EB-2, National Interest Waivers, EB-1s, O-1s, and green card matters. So without further ado, we will get started with the presentation. Okay, so what are the Extraordinary Ability Visa categories? The first ones we have listed here are the O-1A and the O-1B. Specifically, the O-1A is a temporary non-immigrant visa for individuals with extraordinary ability in the sciences, education, business, or athletics. This visa category does have a very high standard in which you need to have be one of a very small percentage who's risen to the top of your field in your profession. We also have the O-1B. So again, this is a temporary non-immigrant visa for people who have extraordinary ability in the arts. So O-1Bs are treated a little bit differently than the O-1As because the standard for the arts is slightly lower. The person for the O-1B must have received distinction, meaning a high level of achievement evidenced by a degree of skill and recognition substantially above that ordinarily encountered. Within the O-1B visa category, there is also a separate category. This would be for people with extraordinary ability in the motion picture or television industry. The standard for those in the motion picture and television industry is a little bit higher than those in the arts. You do have to show that you have a record of extraordinary achievement in the motion picture and television industry, such that you have a very high level of accomplishment evidenced by a degree of skill and recognition significantly above that ordinarily encountered, to the extent that people would recognize you as outstanding, notable, or leading in the field. So that comparison would be in relation to others within that industry, your peers within the industry. So again, these are temporary visas. So with these visas, you would have the ability to come to the U.S. to work, but your intent is temporary. So it's just temporary to come here to fulfill that work. In contrast to a green card would be for someone who intends to come to the U.S. To work and live in the U.S. permanently. Okay, so we'll talk a little bit about which green card options are available for those with the extraordinary ability. First, we do have the EB-1A. So this is very similar to the requirements of what you would encounter or read within the O-1A and the O-1B, but there's not a separate category for the arts specifically. So this category is for those with the extraordinary ability in the sciences, arts, education, business, or athletics, and it's all under one umbrella of the EB-1A. So the individual for this category must be one of a small percentage who has risen to the very top of your field of endeavor, and you have sustained national, international acclaim, and your achievements must have been recognized in your field of expertise. So importantly, the person coming to the U.S. Intends to continue to work in their area of extraordinary ability. So, for example, if you are a person who has had a very prominent career, and you just want to come to the U.S. to retire, this wouldn't work for the EB-1A category. So the government will want to see a statement, a proposed intent of what you plan to do here in the U.S., and it does need to be related to your area of extraordinary ability. So next we have the EB-2 National Interest Waiver green card. This one's not always lumped in with the extraordinary ability visas, but it can be a good option for someone who may have been on an O-1B, doesn't quite meet that EB-1A standard yet, but you still have a very impressive background and you're working on your endeavor in the U.S. that does have substantial merit and national importance. So for the EB-2, you can be eligible for this visa if you're a member of the professions holding an advanced degree or its equivalent, you have a bachelor's degree and 5 years of progressive work experience, or you're a person with exceptional ability. So those are like the basic threshold requirements for this category. Then for the EB-2, you still need to explain and define your endeavor. So the term endeavor is more specific than just a general occupation. You should offer details not only to what the occupation normally involves, but what type of work you propose to undertake specifically with that occupation. So for example, if the occupation is an engineer, then the explanation of your proposed endeavor should describe the specific projects and goals you will work on as the engineer, not just your basic duties as most engineers perform. You would also need to provide a detailed description explaining that proposed endeavor and then provide the supporting documents as evidence to establish that your endeavor is of national importance and does have that substantial merit. You also need to show as an individual that you are well positioned to advance that particular endeavor. So there does need to be kind of a nexus between everything you're providing to the government for them to adjudicate this petition. So um, a connection between, your occupation, what you plan to do, the national importance, and substantial merit. So based on that information that you provide to the government, you would then argue to the government that it would be beneficial to the U.S. to waive that normal labor certification process that requires the U.S. employer in a labor market test, so that you don't have to go through that normal process. Because what you're working on is so important, it is beneficial to have you here in the U.S. One important thing to know about the EB-1A and the EB-2 categories is that you can self-petition. So there is a little bit more flexibility with these categories versus what you would find with the O-1A or the O-1B. So with the O-1A and the O-1B, those are the temporary visas, and you would need to have either a U.S. employer, a U.S. agent, or an agent operating for an employer, a foreign employer, to petition for you. Okay, so we'll discuss a little bit more now for each category, what you would need to provide or show the government in order to demonstrate you qualify for that visa category. So for the O-1A visa requirements, you can show that you have a major internationally recognized award, like a Nobel Peace Prize or Pulitzer, something with that very high caliber. But much more commonly, people are going to qualify on the basis of showing that they meet at least 3 out of the following criteria. So 3 is the minimum. You can provide more if possible, but just 3 as minimum. So first we have here is the receipt of nationally or internationally recognized prizes or awards. For this category, you would want to consider for that prize or award, is it national? So is it the whole nation? Is it international? More than one country. you would want to even consider what is the prize, what is the award. So a prize is something often offered or striven for in competitions or contests. An award is something that's conferred or bestowed, especially based on your merit. So other things to consider would be like the criteria for winning that prize, the past honorees, the number of prizes or awards given each year, any limitations on eligible competitors. So you can think about it really, what was the award? Was this something you won as a student? Was it something given to you by your university or your college? If so, that might not be very compelling to show that you do qualify for this category. Um, and you do want to think strategically about your petition when you are submitting all this evidence to the government. So, the government officer will look at your petition holistically, so everything you're providing to them. So, if you're providing this evidence to show you've won some award from like your university, if the government officer is looking at that evidence, will they look at this award and really say, hey, this person is someone who's risen to the top of their field based on this award? So, when considering what to provide, including things like a student award you won at a university, could possibly lower your profile in the eyes of the government, and they might dismiss it. So, it is something to think about. In contrast, if you did win a prize at a university and it was a very prestigious award, maybe other professionals in the field were competing for that same award, then you would probably want to include that piece of evidence because it could really show that you've risen to the top of your field. So next one we have is membership in associations in your field which require outstanding achievements. Here you would want a membership that actually does require you to have some outstanding achievement in order to be invited or to apply for the membership. Um, so it is important to look at what are the requirements for entry. Can anybody enter or does it require some outstanding achievement? Factors that you might want to think about as to whether or not you can use this criteria is so is the membership based on something like your level of education? Is it based on payment of a fee? So something, for example, like a lawyer, if you are joining the bar, you would have to take your exam, you'd have to pay a fee, but it doesn't necessarily require some outstanding achievement to be a member of the bar. So if you are a lawyer applying for the O-1A, if you're saying, hey, I'm a member of the California bar, this wouldn't necessarily qualify for this criteria. So next we have published material in professional or major trade publications or major media about you or about your work or something you are working on. So for this one, you should consider the material. Is it about you? Or does this publication just cover a very broad topic? Does it include any substantial discussion on your work, or does it mention you in connection to the work? So the government will focus heavily on whether the article was about you, and whether the media where the material was published was major. So you do need to consider all of that. So the next one we have is original scientific, scholarly, or business-related contributions of major significance in the field. So an original contribution could be something like a patent. It could be processes that you've developed for a company. It is important to show really how the work has already impacted the field. Potential impact is not sufficient for this criteria. So often people commonly would provide testimonials about their work, but the testimonials explain, the potential impact of this work, but that would not be sufficient. So if you're providing a testimonial for this, you should really explain in detail how the work has already been of a major significance in the field already. Next is authorship of scholarly articles in professional journals or major media in the field. So this can include publications in professionally relevant journals, published material like a conference presentation at nationally or internationally recognized conferences. Um, So this criteria often applies for those in academics, but it could apply to other fields as well. Next is high salary. So a high salary or other remuneration for services as evidenced by contract or other reliable evidence. So here you are going to be looking again at your area of extraordinary ability. What is your occupation and where are you working? Those types of factors. So are you earning a high salary in relation to others in the field in your area? So you can show this by providing your salary and comparing it to labor statistics. But I always tell people you should make sure you're comparing um, apples to apples. So if you're earning a yearly wage, then you would want to provide labor statistics that demonstrate, like depict the yearly wage versus maybe you get an hourly wage and then you're providing the yearly wage. The government doesn't always accept that. Next is participation on a panel or individually as a judge of the work of others. So here, you must show that you did participate as a judge of the work of others in your same or allied field. An example of this could include reviewing abstracts or papers submitted for a presentation at scholarly conferences or serving as a peer reviewer for scholarly publications. You might document your peer review work by submitting a copy of the request from the journal, which asked you to do the review, and then you could accompany it by evidence confirming that you did complete that review. We also have employment in a critical or essential capacity for organizations with a distinguished reputation. So here you would want to explain your role within the organization in detail how it was critical or essential. I think sometimes people on first pass when they're submitting evidence for this one, they just say that their role is essential or critical. But you should provide that detail explaining, where in this organization of the organizational hierarchy do you sit, or how is your role critical or essential? So critical is that have you contributed in some way that is very significant to the organization or their activities? Essential would be is your role integral to the entity? So usually a leadership role in an organization would qualify as critical or essential for the organization. For this criteria, you do also have kind of a second piece to it. You do also need to show that the organization is distinguished. So is it well known or is it just some tiny little organization that no one's ever heard of? So if you were a CEO of a very small company, you could likely show that your role was critical or essential, but you may struggle to show that this organization was distinguished if it's, not very well known. Conversely, if you worked for a very well-known company like Amazon or Apple, it would be pretty easy to show that that company is distinguished. But if your role within that company of Apple or Amazon was just kind of working in the factory among thousands of other people, it would be very hard to show your role was critical or essential. Okay, so we will move on now to the O-1B visa category, and we'll just discuss what you would need to demonstrate for this one. So again, this category is for those who are in the arts and the motion picture television industry. The O-1B does have that similar structure to the O-1A in the sense that you can qualify by either providing evidence you've earned some very significant national or international award, like a Grammy, or by providing at least 3 out of the following criteria we'll discuss in the next couple of slides. So the first one here that you could show that you qualify for this O-1B would be to provide evidence that you have been and will perform as a lead or starring participant in a production or event with a distinguished reputation. So evidence may demonstrate a lead role by establishing that the person has like a principal role in an event or production, kind of like a main character. A starring role means a position of great prominence relative to others in this event or production. So generally the difficulty with this criteria is showing like the future element. So oftentimes people can show they have performed as a lead or starring participant in a past production that did have a distinguished reputation, but showing the future element can be difficult for people because it can be very hard to show a future production has a distinguished reputation. Oftentimes there's not those critical reviews or advertisements yet for a production. Like for example, if you're going to star in a movie and you filmed 2 years prior to the release, there may not be those advertisements available yet. Okay, next we have critical reviews or other published material in professional or major media by or about the beneficiary. So this one I say like the difficulty can come with showing that the media is major. So oftentimes people will provide evidence they have appeared in publications, but you should look at the type of publication. Can it be considered major? So the government doesn't hold much weight to articles that you can self-publish or that are not vetted versus articles you might find in the New York Times. That's very well known and definitely can tell that would be major media. So you do need to show that um, provide evidence that demonstrates you were recognized for those achievements nationally and internationally in that published material. Okay, so next is evidence that the beneficiary has performed in the past and will perform in the future as a lead, starring, or critical role for organizations or establishments with a distinguished reputation. For this one, it is important to remember here that the critical role is for the organization, not just an event or production that the organization might put on. So this is people often conflate this one with the first bullet point that we just discussed under this O1B, but they are separate. So the first one would be an event or production. This one is really need to focus on the organization. So an event or production, I would say you should think about as something more temporary, but if you're serving in a lead starring role for an organization, it's probably more of a permanent role. So for the first one, it's kind of like, did you perform as an actor in a movie, or did you work for the movie studio as the CEO? So what was your role? Um, but again, you do need to show that the organization that you worked for has this distinguished reputation. There are kind of two parts to this criteria as well. And then it is important to really describe your role within the organization in detail so that an adjudicator could see, that your role was critical. Okay, we also have evidence of major commercial or critically acclaimed successes in the performing arts, as shown by box office receipts or record, cassette, compact disc, or video sales. This criterion does have some outdated evidence requirements on it, so most people don't sell cassettes anymore, but so for this one, you may have to think a little bit outside the box, be a little bit more creative in determining what evidence could apply. So for example, for commercial success, maybe you don't have those record or cassette sales, but you do have a YouTube channel and that YouTube channel is very lucrative. So do you earn money? How much money can you show some type of commercial success monetarily from that YouTube channel you created? Um, if demonstrating like the critically acclaimed success, the evidence should demonstrate that the beneficiary's work has received public-facing praise or positive reviews in the relevant field. From professional art, television, film critics, something like that. Oops, I think let's go on to the next. Okay, so next would be evidence of significant recognition for achievements from organizations, government agencies, or other recognized experts in the field. This is often would be you could submit testimonials for this category or this criterion. The letter or the testimonial, if you're going to get those, should really focus on the beneficiary's achievements. So again, speaking to someone's potential or mentioning that, they're a hard worker, this would not be sufficient. So details on those achievements are really important. Um, You can explain, and it is important to explain to the government, what was the achievements, maybe why something qualifies as an achievement, that sort of thing. Those details are important. Um, for the O1B, you can also provide evidence, like the O1A, that you've commanded that high salary or other significant high remuneration for services in relation to others. So you can again show this by providing evidence of labor statistics. So again, you would want to provide, if you give your yearly salary to the government, you would want to provide labor statistics um, showing your yearly salary is high in comparison to others. So next we have is what is called comparable evidence. So that's to say if you're applying for an O1B in a very kind of odd or niche field, and you feel that any of the criteria we just discussed don't apply to you, then you would need to explain why they don't apply to you, and then explain why the evidence you are providing is comparable to the criteria listed in the regulations. So the comparable evidence is kind of a high or a big hurdle to meet, but it is something you can consider, especially again if you do work in an area that's a little bit more odd or not as common. But it is important to note that the comparable evidence is not available for those in the motion picture television industry. Okay, so here we just have a little bit a chart that kind of discusses or compares the O1A versus the O1B. So again, the O1A is for those in the sciences, education, business, or athletics versus the O1B, which is again for those in the arts and the motion picture television industry. The standard, so the O1A again is the higher standard, is for one of a small percentage who has risen to the very top of their field of endeavor. And then you have those in the arts, which would be the standard would be a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. And then those within the motion picture television industry would be a level of acclaim substantially above that of their peers. So in comparison to those in the industry. So how long can it be issued? So the O1 visas, both the O1A and the O1B, can be issued for initial period of 3 years. If you do have work in this like the same work, you can apply for an extension for another year. Um, if you can argue to the government that you have new work, so you have new employment, new contracts, then you can be hired or extend for another 3 years, potentially, depending on the work. So it would depend on the evidence you're providing in the contract. So just as an example, if you provided new work to the government, but that contract only covered 2 years or required you to be here for 2 years, they wouldn't just give you 3 years. They could give you two. So it would just depend on the evidence you're providing. So let's see. Can your family come with you to the U.S. under the O1A and the O1B? Yes, your family can join you. That would include your spouse and unmarried children under 21. So the children could attend school while in the U.S., but unfortunately, if your spouse did need to work, they wouldn't be able to have that work authorization as the O3 dependent. So they would need to find a different visa category if they needed to work that would allow them to work. Just one note as you're comparing these two categories, because the O1A is the higher standard, it can be a little bit more difficult to obtain that visa. So if you're in a field that could be considered maybe the O1B versus the O1A, then that might be a better choice for you um, overall, so that you can get that visa approval. Okay. Okay, so we will discuss just now go over the extraordinary ability for the requirements for the EB-1A. So this is very similar to the O1A and the O1B, but some of the language is a little bit different because it does incorporate everything under that one umbrella again. So altogether, you do have the arts, sciences, education, business, athletics. So the structure is very similar where you can qualify with one major award. However, many people will still qualify based on showing they meet at least 3 out of the following criteria listed in the regulations. So the criteria are the same and or very similar to what we just described in the previous slides, but again, I'll just read through them quickly. So you can qualify for the EB-1A by demonstrating at least three out of the following. So it would be evidence of a receipt of lesser nationally or internationally recognized prizes or awards for excellence, evidence of your membership in associations in the field which demand outstanding achievement of their members, evidence of published material about you in professional or major trade publications or other major media, evidence that you've been asked to judge the work of others, either individually or on a panel, evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance in the field, evidence of your authorship of scholarly articles in professional or major trade publications or other major media, evidence that your work has been displayed at artistic exhibitions or showcases, evidence of your performance of a leading or critical role in distinguished organization, evidence that you have commanded that high salary or other significantly high remuneration, or evidence of your commercial success in the performing arts. Okay. So we are going to switch to Jiyae now, who's going to discuss a little bit more about the EB-1A green card and their requirements.
All right. Thank you so much, Katie.
Mhm.
All right. Now let's go into a little bit more detail about how does adjudication work for the EB-1A green card pathway. So as we mentioned, the language of the requirements are quite similar to the O-1A, as we discussed in the previous slides. Either you show that you received a major internationally recognized award, such as, a Nobel Prize, I guess, or something of similar caliber, or in the vast majority of cases, meeting at least 3 out of 10 criteria that Katie just went over in the previous slide. Now, one thing to note, though, is that for the EB-1A, and this is what USCIS does as a practice, is that the USCIS traditionally applies what is called a two-step analysis. It's called a Kazarian analysis, which was adopted from a case called Kazarian. And what the USCIS does is that not only do they look at whether you met the plain language of at least 3 out of the 10 enumerated criteria that we just went over, but there is also a holistic element, a holistic comprehensive assessment element where the government looks at the whole volume and quality of the evidence and asks whether, as a totality, does the paper submitted tend to paint a picture of someone who has really risen to the top of their field? So for example, if you met the media criterion, but the media was one of the smaller types of media, and maybe it was only one article, and maybe you did have a scholarly article published, but it was only one article, and it was in a smaller journal, and you can't really show how impactful that was, and then maybe you meet one other criteria. So technically, you may meet the plain language of 3 or more criteria, but the government still has the option to look at the totality of the evidences and say, well, the totality of the evidence, when we look at it comprehensively, actually does not tend to paint a picture of someone who has actually risen to the top of their field. So the quality and quantity of evidence would matter in this case. So they would not only look at whether there was a media article about you, but how prestigious does that media article represent, right? So was it an article in the New York Times, or was it an article in a smaller, more obscure trade publication? So yeah, the Kazarian analysis really makes it a little bit more difficult for individuals to qualify for the green card under the EB-1A classification. And actually, we're seeing kind of lower approval rates across the board as time goes on. Right now, I think it's hovering around 50%. So definitely EB-1A is one of the more discretionary and more difficult classifications of green cards that's available, and also one of the more popular ones, right? Because it allows self-petitioning without a U.S. company to sponsor. So definitely get a experienced lawyer to look at your profile and do both. Not only whether you assess whether you meet the 3 out of the 10, but also holistically, what does your profile realistically present in terms of EB-1A possibility. Now, one small note to mention here is that in January 2026, there was a case where a federal district court in Nebraska where the judge ruled that actually this Kazarian test was not lawful. Now, in terms of remedies, the remedies are really limited just to the parties of the litigation at this point. And I believe USCIS is still using Kazarian, and there has been no other announcement or pronouncement um, that USCIS confirmed that they're not going to use Kazarian in the future. But definitely, it is an interesting argument to note that the argument that the Kazarian test was unlawful did work in at least one case. So if you're, someone whose, a case was denied based on Kazarian, maybe you could consider litigation as a potential option. But yes, definitely something that we are looking regularly to see if there are any broader implications of this decision. But yes, this definitely is an interesting development that happened in 2026. All right, so now let's move on to the another category of green card that we can explore. And the NIW is not exactly an extraordinary ability visa classification, but there practically is a lot of overlap between clients who tend to want to explore the O-1, EB-1A, and clients who tend to also qualify for the EB-2 NIW. So definitely this is an option that we can think about. So the difference between the NIW and the EB-1A is first that the NIW has a degree requirement. So there's a threshold requirement. You need to be able to show that you're qualified under the EB-2 classification, which either you can show by you have an advanced degree, which is defined as a master's degree or higher. Um, if you have a bachelor's degree in your field and if you have 5 or more years of progressive work experience after you received your bachelor's, you can be considered an equivalent of a master's degree holder. Interestingly, if you have a foreign degree, if it's not a US degree, you need to also show that your foreign degree is equivalent to a US master's degree or bachelor's degree if you're using a bachelor's degree. So that one is definitely an important nuance to consider. But if you do have that, you will be able to qualify under the EB-2 classification. If you don't have a degree, if you don't have the master's, if you don't have the bachelor's, if you can show you have exceptional ability in the sciences, arts, or business, you can also use that as the pathway to be classified as EB-2. And in order to show that, you must meet at least 3 out of the 7 criteria to show exceptional ability. Now, one thing to note is that exceptional ability is a lot lower standard than extraordinary ability. So it'll be easier to meet, right? So, for example, you can show 10 years of work experience. You can show membership in any professional association that's related to your field. It doesn't need to be an association that requires extraordinary ability of its members, like it was in the case of the EB-1 or the O-1. You can show recognition for your achievements and significant contributions to your field through letters and other types of evidence. So you can see that the language of the elements here are a lot more forgiving than the high standards that we just talked about in the EB-1A context. So definitely, exceptional ability would be reachable for a wider range of people. But the important thing is that meeting the EB-2 threshold is not the end of the story. You also need to show that your prospective work in the United States will have national importance. And that's where a lot of the difficulty comes in, because you need to really focus on the future and what would be the future impact of your work, and would it go beyond just helping your immediate clients or helping one particular employer, but will it advance the field as a whole? And it's a little bit easier said than done, right? How can you prove that your work will have such a transformative impact in the industry? So you do need to be able to show that special factor. We can go on to the next slide. So the real challenge in an NIW case is the EB-2 threshold, I would say, in comparison, is a little bit more straightforward to meet, but really the meat of the challenge is whether you can show that your work has national importance. So we do have specialized webinars just on the NIW. So if you're really interested in the NIW pathway, you can definitely check us out in the more dedicated webinars on that. But to just go over the basic details, you would first want to prove that your endeavor would have substantial merit and national importance by, you know, showing evidence, and this can really be helped by powerful expert letters from people who are actually involved in government or involved in major U.S. institutions in your particular field, talking about what you intend to do in the U.S. and why that particular project will transform the industry forward in a broad way, right? Why your work is at the cutting edge, why it will improve existing approaches. And you can't just be doing what's already here in the market in order to have that sort of broad impact, right? And you would also need to show that you've already made that kind of broad impact in your field. And we can look at the second prong, which is that you need to show you're well positioned to advance your proposed endeavor. We would look at your education and experience, but also really a track record of success, right? A track record of having influenced the field in the past. So if you're a researcher, you want to show that you've authored papers and made presentations, and those papers have been cited a high number of times, and not only just with your co-authors, but people who don't know you, all over the world. They've been citing to your work, they've been discussing your work. Your work has generated a lot of public discourse. Those kinds of impact evidence is very important because that shows that your work doesn't only benefit your immediate employer or your immediate clients, but actually advances the field in a broad way. So not everyone would be a good candidate for a national interest waiver. You do need to show that you're someone who's operating at that advanced level and have sufficient evidence of having influenced your field. There must be a showing that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And that really ties into what we've already been talking about, is that if your work is just, doing the run-of-the-mill duties, if you're an engineer, you're just doing, engineering duties for a company like Google or Facebook, you're doing AI engineering, but it'll mostly benefit Google itself. That in itself actually is not sufficient to be approved for an NIW, right? Because what the government is looking for is not a good worker, but someone who is advancing the field, right? Because that is the broader benefit that that makes it worthwhile for the government to exempt the labor certification requirement. Because if it's just for a worker, the government prefers that the company hire a U.S. worker or show that there are no U.S. workers who can fill that job, right? So just doing your job is not going to be sufficient. But if you're doing something else, which is, advancing medical practices or advancing a critical manufacturing technology at the cutting edge of the field, things like that. If you can show that with sufficient evidence, then that would be a better NIW case and be the road towards qualifying for the green card through this particular classification. All right, so now let's shift gears, talk a little bit about expert opinion letters. Expert opinion letters are a very important element of all of the visa categories that we've been talking about today, the O-1, the EB-1A, the NIW. So let's dig into a little bit of that. So for these types of petitions, it is good to obtain expert letters from key individuals in the industry. It can be past employers if you're trying to, if you're trying to prove for the O-1, for example, if you're trying to prove that you played a critical role for an organization that has a distinguished reputation, you would want to get a letter from that distinguished organization, it's the CEO of the company or, someone senior who can testify to your critical role and explain why it was critical. Those kinds of letters are definitely part of case presentation in, preparing the evidence. Your colleagues, clients, professors, Nobel Prize winners, really the exact identity of the expert that we're choosing depends on what we're trying to prove. So for example, if we're working in an NIW context, if we're trying to prove that your work has a national importance, we would definitely prefer getting a letter from someone who's affiliated with the government, right? So for example, a case where is an entrepreneur and the entrepreneur is going to revitalize a particular city or a region where it's economically underdeveloped, then maybe you can get a letter from the mayor. talking about why this particular business is really making a huge impact on, improving hiring for this particular underdeveloped region. So really the choice of what letters to get is very tailored uh, in terms of what would be the most helpful for arguing that particular point. So really it's not a cookie cutter approach that we use. If you use a cookie cutter approach, USCIS will see that immediately, and it would not be effective, right? Because every single case is different, and every single case, requires different areas where holes need to be filled, right? So that's the idea. Um, so yeah, who is writing the letter is very important. We want to provide the background information about um, the person who is writing the letter. We would typically include a full-length curriculum vitae, a CV, a resume of the person who's writing the letter. The more accomplished and senior this person is in the industry, the more reliable the opinion will be, especially if they are giving an opinion about, how your work stands to impact the field for an NIW case, or in the case of an EB-1A or an O-1, it is more past looking. So what have you done in the past, and how did your achievements already impact the industry, right? So those kinds of narratives would be more compelling if they were coming from someone who is already well known in the industry. So we would need to provide evidence regarding this person's background as well. Um, how does the individual know you? So it is important to have a mix of independent letters and people who that you've worked with before, so and who have personal knowledge over your work, because both of these letters have different purposes. So for an independent letter can provide a more objective account on the significance of your achievements in an industry, right? Because if it's just another person who doesn't know you, but they know your achievements, then it's, more independent, right? It's like, oh yeah, I know this person's work. This person's research really helped, improve medical practices on that particular disease. So yeah, so independent experts can definitely provide compelling evidence of that. Whereas people who know you and people who've already worked with you before, those people can discuss more about your personal roles in a project in terms of maybe, proving critical role, right? Significant contributions that you've made to, a particular element. People who have personal knowledge over the nature of your contributions can really speak compellingly to that, right? An organization, a leader of a distinguished organization can directly confirm why your contributions were of significant importance. So we want a mix of different letters, types of letters to serve different purposes. And the content of the letters. So we want to make sure that there is sufficient discussion about what you've done, why it was important, and why what was the impact of your work, right? So we really want to give the USCIS enough detail about the details of what you've done, because if the letter is very conclusive, and this can happen if you're maybe using AI to draft the letters, or if you're using a template or something, really you would end up with a letter that sounds good but doesn't have a lot of substance in it, right? If anyone can say that your work was critical, anyone can say that your work was important, right? But only the concrete details is what makes it compelling, right? What makes it persuasive. And you really want to approach this as an exercise of persuasion. What kind of detail do you need to provide the USCIS officer to give them the sense that, okay, this person really knows what they're talking about? So that kind of strategy is very important in case preparation, and this is where we can definitely provide our expertise. All right, so now we'll move on to the next slide. So let's talk a little bit about some strategic questions you may want to think about when you're trying to choose which category to apply for. We've discussed the O-1, we've discussed the NIW, we've discussed the EB-1A. Now, the first important question is, do you want to stay in the United States temporarily or permanently, right? And Katie already went over this, but O-1 visas are non-immigrant visas. They're well suited for temporary work arrangements, you can definitely continue extending your O-1 if there is still ongoing work for the future, right? So you can extend for 3 years if you have a new set of projects, and you can continue extending it. There is really no lifetime limit on how long you can be on an O-1 visa, for sure. And if you don't move over to a green card, the O-1 visa can give you some flexibility with regards to how long you can stay outside the United States and things like that, right? So if you have, you know, uh, lots of need to travel for a long time, you have close ties to your home country, maybe the O-1 visa would be perfect fit for you, because you don't have, the responsibilities that come from being a green card holder. Now, EB-1A and NIW are green card categories, and it's well suited for people who want to live and work in the US permanently. And once you get the green card, the pathway opens up for US citizenship as well. So that's another important reason why people want to go for the EB-1A and NIW. But on the flip side, being a permanent resident does come with responsibilities. So definitely look into that. It may or may not work for everyone. The second question to ask is, do you have a U.S. employer or agent, or do you want to self-petition? So it is important to note that the O-1 visa requires someone other than you to act as the petitioner. Now, you can use an agent. If you have an agent, a U.S. agent who is a U.S. citizen, this person can be the petitioner and be, the person who signs your agreements with other entities in the United States. So you can definitely do that. Another option you can use is if you are an entrepreneur and if you found a new company in the United States, like, create an LLC or something in the US, you can use that entity as the petitioner because the entity is a separate legal entity than yourself. The important thing to note is, though, that we need to convince the USCIS that this is actually not just a paper company, but there is actually a real work opportunity in the United States that's related to this entity, right? So you would, likely provide copies of contracts between this LLC and other entities, or a business plan, or some other evidence that there is ongoing work in the United States that's lined up for you, so that is more than just a paper entity. EB-1A and NIW, by contrast, they are both self-petitionable green card categories where the foreign national is able to drive forward the case by themselves. They don't need any U.S. employer or agent to do that. But keep in mind, though, that you do need to present some sort of plan on what you need to do, what you want to do in the United States in terms of the EB-1A. And for the NIW, you need to convince that there is a proposed endeavor and that it will have a national level impact. So you will need to have that, that evidence of traction, I guess, to have to meet the other aspects of eligibility. But technically, yes, you can be the one who drives forward the petition. You don't need a separate petitioner. Family considerations. For the O-1 visa, your spouse and children under 21 can come with you to the United States as O3 dependents, and your spouse and children can study in the United States, but unfortunately, work authorization is not available for the O3 spouse. By contrast, for the EB-1I NIW, those are green card options, and dependents have the ability to apply for a derivative. Green cards as derivative beneficiaries. And so, for example, if your spouse applies with you for the I-485, for example, they're also able to get the associated benefits such as the EAD and, the travel authorization and things like that. So your dependents will definitely also be able to apply and get green cards. All right, so now some other strategic considerations when moving from a non-immigrant visa to a green card. The first question to note is different qualifications. There is definitely a higher standard to qualify for the EB-1A as opposed to O-1A or OMB. And it can even be a larger jump if you're going from an OMB to the EB-1A. That can be a significant jump. So qualifying for an O-1A or OMB does not mean you automatically qualify for an EB-1A, especially because even though the language of the regulations are drafted quite similarly, in practice they are interpreted differently. So a common strategy is for someone to come in on an O-1 and then spend several years really building up their profile and collecting the types of evidence that could potentially support a powerful EB-1A petition. So O-1 to EB-1 definitely is a common way. I've also seen people go from O-1A to NIW. That's also a common pathway. So definitely there can be synergies between O1 and EB-1, but it's just not automatic and it's never automatic. Okay, second question, timing. Consider how much time is left on your current underlying visa. Some visas are harder to extend or subject to more scrutiny once an I-140 or green card petition is filed. So for example, if you need a new F1 visa, if you need a new TN visa, for example, you really want to speak to your lawyer and think about what is the ideal timing of when you submit the I-140, because maybe you want to renew the TN first and then consider doing the I-140. Depending on the type of your visa. H-1Bs and L visas are not affected; they're dual intent. But for other types of visas, your application may be subject to more scrutiny. Family considerations. If you have children that may also need the green card, definitely consider filing early because you will get issues once the child turns 21, no longer will be eligible for the green card. So you want to make sure that you calculate enough time in advance to allow for the processing and priority dates being current and things like that. You may want to file early enough to avoid getting into that aging out problem. All right. So next slide. Yeah, this is the last question we will answer before moving on to the questions and answer part, and it's a live Q&A, so please feel free to ask any questions you may have had. The question is, are extraordinary ability categories available for entrepreneurs? And the resounding answer is yes. We have had many approvals for extraordinary ability visas for entrepreneurs. Let's look at the EB-1A and NIW. They are options that both allow for self-petitions, meaning both are possible options for entrepreneurs. They don't need a separate job offer or anything like that. Changes in the NIW standard under a matter of DANISAR made NIW a much friendlier category for entrepreneurs. This is true. After DANISAR, which came down December 2016, we've definitely seen a lot of entrepreneur cases being approved. Government has been looking at entrepreneur cases with a little bit more scrutiny in recent years with the NIW, just talking about the NIW. So you would definitely need a very precise strategy on how you're going to convince that your work not only benefits your immediate clients or helps just your private bottom line, but how does your work transform the industry? And that is actually easier said than done. So that would be, I think, the linchpin of a successful NIW case for an entrepreneur. Finally, it is possible to apply for an O-1A visa as an entrepreneur if you can show that you have extraordinary ability in business in your particular field. However, you can't self-petition for an O-1A. You must have a separate entity, either an agent or an LLC or an Inc. that you make, a U.S. entity that can act as the petitioner. It is okay for you to have ownership interest in the separate corporate entity. You do need to show that there is a bona fide work opportunity for that entity. All right, so now let's move on to questions. It looks like we have one question that came in through the Q&A. For the EB-2 NIW, does aerospace and defense contributions fit in the requirement along with a corporate director certification for board readiness? Now, I believe you're talking about the EB-2 threshold requirement. So for threshold requirement, definitely if you've earned recognition for your work in the industry for contributions to the aerospace and defense, you would use, expert letters and awards and other types of evidence to prove that you've earned that recognition. Similarly, certifications are also relevant, academic certifications, diplomas, things like that, that's related to your proposed endeavor and area of expertise. You would use that as part of the 3 out of the 7 exceptional ability criteria that you argue. However, the important thing is that that is not the end of the story. You still need to prove that your work in the United States prospectively will have national importance. And just working in an important field such as military is not enough. You need to show how your particular project in that field will advance the field. And so, in a case like that, if you're working on aerospace and defense, you really want to get concrete evidence of U.S. entities being interested in your particular project, right? So you could get, a letter from NASA or something like that, talking about what you're trying to do and why it's important to the United States. You really need concrete evidence showing that what you're doing has that transformative potential. Just saying it and just saying that you're going to work in aerospace is not going to be enough, especially in this adjudicatory environment. You really need more materials to support that. Expert letters can really go a long way, especially if it's from, relevant U.S. entities covering the field, like NASA. It doesn't have to be NASA, but the more authoritative the agency is, the better. Anyway, any other questions? Maybe give or take 10 more seconds for any other questions to come through. Okay, we have one more question. Can you apply to an EB-1A and O-1B simultaneously? Katie, do you want to take this question? Oh, you're on mute. You need to unmute you.
Sorry.
No worries.
Yes, you can apply for more than one visa at the same time.
Yes. And if you want to do the O-1 visa and the EB-1A, maybe do the O-1 first, because depending on where you're applying for your visa, you just immigrant intent is always kind of a discretionary element in consular visa processing. So if you need the visa and if you're outside the United States, you may want to get the O-1 visa first, come inside, and then file the I-140 or something. But definitely talk to your lawyer with regards to the specific timeline of that. Can I change from F1 visa to EB2 NIW, and what must be the strategy? That can be tough. Definitely reach out to us for a consultation. Um, Filing the I-140, you want to be careful though when you file the I-140, because once you file the I-140, if you need a new F1 visa, for example, the F1 visa is a classification that requires non-immigrant intent, showing of non-immigrant intent. So you want to really look forward to what the timeline will be. And the other thing is, if you're trying to show that you're well positioned to advance the endeavor, and if you're trying to show national importance of your project, you'll need to have made some progress on your project, but it needs to be consistent with your work authorization. So as an F1 student, you can't really work. If you're an OPT, STEM OPT, maybe you can work, but your proposed endeavor should be aligned with that. So definitely a lot of difficult strategy that goes into this. Definitely reach out to us for a consultation, and we can go into more detail. But yeah, going directly from F1 to NIW, not always easy. All right. All right. Well, that was great. Thank you all for all of your active participation. Yeah, definitely reach out to us for a consultation. We will be happy to look into what options that can be workable for you. For F1 students, we've also had cases where we've helped the person change to an O-1, and then from O-1, you can, think of other options for a green card. So definitely many different strategies can work for many different situations. And thank you, Katie, for sharing your excellent expertise.
Thank you. Bye.
Okay, bye-bye, everyone.